Welcome. My name is Professor Theo Bredrak. I am an Associate Professor of Law at the Stellenbosch University Law Faculty. I also head up the Stellenbosch University Law Clinic. I'm pleased to be joined by Dr. Bernard Wessels to briefly discuss a publication which he has authored and which was recently released. The book is titled The Legal Profession in South Africa, History, Liability and Regulation. The book is published by Jutta and Company, Pty Limited. Dr. Wessels was admitted as an attorney of the High Court of South Africa. He is the head of the Private Law Department of the Faculty of Law at Stellenbosch University. He's also the lecturer of the law of dealing. Apart from having practiced as an attorney at one of the premier law firms in South Africa, he has also obtained his BCL degree from the University of Oxford and his doctoral degree from Stellenbosch University. Dr. Wessels, firstly, congratulations on the publication of your book. And then secondly, thank you for the opportunity to discuss it with you. Perhaps?
Yeah, first of all, thank you, Theo, for taking time out of your schedule to discuss aspects of the publication. I appreciate that very much, and I hope that we will cover some terrain today, and it will be a thought-provoking and interesting discussion to people interested in the publication of this book.
Wonderful. Perhaps you can start by explaining why you wrote this book and why you decided to concentrate on this topic specifically.
Well, honestly, I never actually intended or planned to write a book about this particular topic. What had happened was that the late Henny Erasmus, who was emeritus professor in the Department of Private Law at Stellenbosch Law Faculty and a retired judge of the High Court, he, shortly after I joined the faculty, approached me with the invitation to write a chapter on professional liability of legal practitioners. And I think the idea was that they would put together a bigger edited volume on professional liability in South Africa generally, so medical practitioners, legal practitioners,
Yes.
accountants, and so on. And because I'm interested in the law of dealing, I was interested to write particularly about the lecture liability of the legal practitioner. So I jumped at the opportunity. I completed my chapter, submitted it to Professor Erasmus, only to be told that for whatever reasons that particular project was never finalized. But he did encourage me and said I should try to sort of develop the chapter into a self-standing title or book. And yeah, I took his advice. I approached Jutta with the idea. They were very interested and similarly motivated me. So to cut a long story short, that's really the way the book came about. Of course, the book in the end, it doesn't deal only with liability of legal practitioners, but also with the history of the profession in South Africa, as well as the regulation in South Africa. But I think the extended scope of the project came about partially because of the enactment of the Legal Practice Act, which, as you well know, yes, radically altered the regulatory landscape for legal practitioners in South Africa. So that was one reason. And then secondly, sort of an increasing awareness of the importance to engage with the history of the profession. So that in a nutshell is why I decided to tackle this particular topic.
It's very interesting. I'm pleased that you've touched on the aspect of the book not focusing solely on the issue of liability. And it links to the title of the book, and that's my next question. The title of the book, I'd like to remind the audience of the title. It's The Legal Profession in South Africa, History, Liability and Regulation, and it speaks to that point that you made. It gives the reader some idea of the content, but can you perhaps elaborate a little bit? What is the book about?
Yeah, as the title suggests, I try to tackle three main topics. Firstly, the history of the profession in South Africa. Secondly, common law liability of legal practitioners. And then thirdly, the issue of regulation. So yeah, just to say something about each of those topics. Firstly, insofar as history is concerned, the first main chapter of the book focuses on that topic. And the overall idea really is to provide an overview of the historical development of the profession in South Africa. So that requires quite a number of things. I think firstly, what I try to do is to briefly describe the historical foundations of the profession as it may be found in Roman law, Roman Dutch law, and English law. I also touch on African customary or South African customary law, but as Mjongani and some other authors have made the point, you know, the sort of African customary law didn't really recognize the concept or the notion of a legal practitioner, certainly not at the time of colonization when the legal practitioner was brought over to this part of the world. So if you are interested in looking at the historical foundations, you do have to go and look at the legal systems of the Dutch, the English, because, you know, they colonized South Africa and they brought that idea. Yeah, but that is really just a small part of the chapter. I also tried to look at colonization, so the period from 1652 onwards to about the middle of the 20th century. Tried to explain briefly how did the practitioners establish themselves in the rest of South Africa? How did they qualify as professionals? And so on, and also looking at the evolution of the profession during the apartheid regime, and finally, you know, touching on where we are today in a post-constitutional democracy, looking briefly and introducing the idea of the Legal Practice Act. So that is broadly the idea, just to give a, you know, the development of the profession. But I have to say that in the process, it became quite important for me also to deal with the large-scale discrimination, really, of Black South Africans, but in the case of this book, really Black legal practitioners and women legal practitioners, because, and I think this might be the case in other jurisdictions too, you know, where the profession is established, that, you know, it's a positive thing. It leads or contributes to the development of the country, taking it forward, but you know, the story of the profession, at least in South Africa, is also very much a story of exclusion, as we all know. For the greatest period of time, entry into the profession was limited to men, to white men. So, I mean, that is just an historical fact. So if you want to deal with the history of the profession, you do have to tackle that idea of exclusion. So for that reason, I deal with a couple of sub-themes also in this history chapter, thinking about the role that legal practitioners and the judiciary to some extent played in maintaining a fundamentally unjust regime. Also asking, you know, who were the first Black legal practitioners to practice in South Africa? And to that extent, I relied quite a bit on research of others, and notably a book by Tembeka Ungai, The Land is Ours. You know, he deals with that issue of the first Black legal practitioners, and I thought it would be necessary to integrate that, because if you have a look at the standard works about the profession in South Africa, or where the aspects of the profession comes to the fore, you know, that is not really brought into the narrative. So I thought that needs to happen. And similarly, with regards to women, I thought it is important to give an account of the discrimination that we saw there. I mean, women were only allowed to enter into the profession after the enactment of the Women Legal Practitioners Act, I think in 1923. So that was also important. And then finally, you know, dealing also a little bit with the history of regulation itself, how was the profession regulated in a pre-constitutional South Africa, and how do we regulate it after becoming a democracy? And I think that is important because it helps you to understand a little bit the calls for development and for reform that that perhaps reached the highlight in the early 2000s and ultimately, you know, realized or led to the enactment of the Legal Practice Act. So that is really the history chapter. Then the second big theme of the book is liability. And yeah, I dedicate 3 separate chapters to this theme, dealing with the intellectual liability of legal practitioners, secondly, contractual liability of legal practitioners, and a chapter dealing with the legal nature of relationships between practitioners and third parties. So when it comes to intellectual and contractual liability, the idea is, you know, basically to set out the applicable legal rules and principles that govern liability in these 2 different contexts in a clear, hopefully coherent fashion. And then also, you know, to guide practitioners to explain how these principles have been applied by the courts in a series of factual scenarios where the courts have actually imposed either contractual or intellectual liability. And you know, when I wrote the chapter about contractual liability, it was clear if you look at the cases, you know, most of those, if not all of them, really deal with the liability of attorneys towards clients. But I started thinking about the question, what is the liability, potential liability of an advocate towards clients? And bear in mind that under the new act, we make a distinction between counsel and trust account advocates. So can these forms of practice, can these types of practitioners enter into a contractual relationship with the client? Can they be held liable? Can they sue for outstanding fees and things like that? And that question was at the back of my mind all the time. And I remember at one event, I won't mention any names, but I asked a retired judge as well as the SC these questions, and I got completely different answers. So that led me to the idea that I think it's worthwhile to investigating that. So actually, the chapters about liability is preceded by this chapter, you know, focusing on those questions about the relationship between practitioners and other people. And then finally, regulation is the third theme. And the idea is, you know, one chapter is dedicated to the Legal Practice Act, as well as all of the rules and the regulations issued under that act, just to set it out, again, also sort of in a coherent fashion, because if you look at those documents, you're sort of presented with a labyrinth of, you know, some of the rules are there, some of the things are over there. So just to bring it all and consolidate it in one central place. And then another chapter focuses on legal ethics, the code of conduct, professional conduct. And the final chapter is dedicated to the idea or to the concept of cost orders, which we see on an altogether more increasing basis being handed down by courts. And of course, that is the court's way to regulate misconduct among practitioners. So yeah, I think that's a mouthful, but that's essentially to give a summary of what the book is about.
A mouthful, but exceptionally fascinating and interesting. And I find it insightful, Dr. Wessels, because these are the issues that as a manager of the law clinic, I know we deal with on a regular basis. We are confronted with, especially under the auspices of the new Legal Practice Act, which, and you've spoken about it, a core theme is transformation in broad terms and specifically from the perspective of the transformation of the profession itself. But you know that I've knocked on your door a couple of times for advice and for insight. And so I'm pleased to hear that many of these issues, if not all of them, are addressed in this book. So I know why I would purchase the book. But could you perhaps just generally speak to why you would encourage someone to purchase the book? I think that would be useful.
Yeah, no, sure. That's a good question. So I think, you know, so in other words, what makes it important to deal with these things? Well, it's a vast history. Let's start with the history section again. I can think of two fundamental reasons, you know, I think why it is important to deal with that and to read it and to be aware of it. First is, you know, it's true that the book is fundamentally about liability and regulation, and you could say that at the heart of all of that is a question: how should legal practitioners conduct themselves? What are the duties that are imposed on them in contract law, but also otherwise? What are the ethical duties, the statutory duties, and all of that? You know, all of that really, I think and believe, is informed and should be informed by our history. Essentially, if we want to know how legal practitioners should act, we have to get a good understanding of how they acted in the past, because ultimately we want to improve. We want to make things better. We want to provide meaningful legal services and promote access to justice and be better legal practitioners, making a positive, meaningful contribution to society. And I think that you can only do once you have a thorough understanding of what went wrong in the past. You know, it's essentially that old thing. If you want to know where you're going, you do need to have a sense of what the past is. And the second reason, perhaps, as you would also know, in universities, at least in South Africa, there's been quite a little bit of talk about developing the law curriculum for law students. There have been some calls for decolonizing the curriculum and so on. And I guess all I want to say in that regard would be that, in my view, meaningful reform, change to the curriculum really can only take place also if you have a proper understanding of the past and what went wrong and what you would like to fix. You know, if you want to improve, you do need a sense of what went wrong. So, I mean, there are many more reasons potentially why, but I think those are two of the more important ones. About liability, I guess, I hope it would be sort of, there's an obvious answer here. So, I mean, there are legal principles and rules governing the conduct of practitioners, and, you know, that impose duties in contract law, but also, you know, otherwise on practitioners. And when they breach those duties, they can be asked to pay compensation, damages to clients, disgruntled clients, or third parties. And so I guess from a negative point of view, it makes sense to understand exactly those sort of rules and principles so you know exactly what you should do. And to add to the compensation issue, if you know, there's also the issue of reputational damage. I mean, if you are, you know, a bit of somebody who's been found to be negligent in providing your legal services, people will be hesitant to go to you to ask for your legal services. So for that reason, I thought it's important to put all the principles and the rules in one central place, and to then also give people indication of exactly where courts have imposed liability in the past. So if you are unsure, you can go to the book and potentially also use the book as a reference tool to consult relevant cases, make sure you're on a sure footing and avoid any of the mishaps. You know, there is a book about liability of legal practitioners, one book in South Africa by Professor Rob Mitchley, but that was published in 1991, I think. So, you know, 30 years have passed, the law has developed radically. So it's it was time, I thought, for you know, an update and to put all of that in one place. And with regards to regulation, I think similarly, one could say from a negative point of view, you need to know as a legal professional and legal practitioner what the rules are that govern your profession, regulating your profession, because if you fail to do it, you can be guilty of misconduct, and that could have dire consequences, not the least of which is removal or suspension from office. So I don't want to exaggerate, but the failure to comply with basic regulations and rules could literally mean the end of your profession. So it's absolutely crucial. I mean, legal practitioners tell other people, it's their job to tell other people, you know, what the rules are governing their industry, but it's equally important for practitioners to understand the rules regulating their own profession, and that they should comply with that. And on a positive note, I think that regulation is a good thing and that people should be aware of it, because it helps us to ensure quality legal services, adhering to all of these values which the code of conduct tries to capture, things like honesty, integrity, independence, access to justice, promoting social justice, adherence to the values and the rights in the Constitution, and giving effect to it. We want to see that from legal practitioners, and for that reason, that's a positive reason. I think you would like to make sure you're on top of your game with regards to regulation. So yeah, and I mean, the Legal Practice Act is a new act for a lot of people. So hopefully this will also assist in familiarizing yourself with the provisions of that act and how it may impact on your day-to-day business as a practitioner.
I have absolutely no doubt that it will assist. Firstly, the fact that it's a consolidated source of those rules and those principles to which you refer. Secondly, to my mind, the fact that the Legal Practice Act was transitionally implemented also made it a bit of a potential minefield. So for various reasons, one of which to which you've alluded, and that is the potential liability of practitioners, I think the reasonable practitioner would certainly ensure that they know what the act, what the code of conduct, and so forth provide in relation to their roles, their responsibilities, their obligations, and their expectations. Their reasonable expectations could be within the legal profession. So I absolutely agree with you that it's a very useful source. But it leads to my next question: to be consulted by whom? Who do you think the target market, or I shouldn't say think, who is this book aimed at? Who is the target market for this book, Dr. West?
Well, first of all, I think to make it really clear that I think primarily the book is marketed at, focused on legal practitioners, people in practice who run a practice, who are practicing either as an attorney, but not only as an attorney. If you are a trust account advocate or counsel, hopefully, you know, this will be a valuable tool, as you suggested in on your library, that you can consult whenever you want to make sure that you comply with any of those regulations or rules or provisions in the Act, or whatever other issue you might potentially encounter. So that is first and foremost, that was at the back of my mind. And that's why, for instance, in the liability chapters, I thought to myself, how would a practitioner think about it? They would want to know, you know, what are the provisions governing liability in very specific scenarios. So I tried to set it out in that fashion to assist them, you know, and it's so that it's also easy to use, hopefully user-friendly, and so you don't have to trawl through the entire book to get to your answer. So that is absolutely my focus. But having said that, I would think, you know, the title of the book is The Legal Profession in South Africa. So hopefully anybody who has got an interest in the legal profession will find it interesting. maybe law students, I think, who want to get a better understanding of the profession which they are about to enter, what the profession expects of them, to help them prepare, whether they're first year law student, a final year law student, or a candidate legal practitioner. Maybe it could be also of some use to somebody in that position. And then finally, throughout the book, I did also address certain topics or questions which I thought from an academic point of view was quite interesting. Things like, what is the legal nature of the relationship between counsel and client, or between trust account advocate and client? Issues surrounding representation and authority, concurrent liability in delict and contracts. What is the nature of the code of conduct? Is it purely an ethical document? Is it a legal document? Does it also impose legal duties on us as legal practitioners? What are the principles exactly governing these cost orders? What type of situation can they really be handed down? And I thought that some of those issues, also regarding legal ethics, the impact of legal ethics, generally speaking, the role of ethics in also the education of law students, all those things I thought deserve also a little bit of attention from an academic point of view. So people interested in those fields would hopefully also get a little value from the book. I'm not saying that I'm right about all of that at all. If you're interested in research, I don't think you should attempt to solve a problem perfectly, but hopefully it will contribute to further research and to take us forward in areas where I think we haven't seen enough research, academic interest yet. So but predominantly it's for people in practice.
Thank you. Yes, I can certainly see it being relevant for practitioners of the broad spectrum of legal practice within South Africa. But as someone who has one foot in practice and one foot in academia, I agree with you. I do think it adds much value to academic discussion and debate on those three themes under the auspices of the legal profession that you discuss in the book. So my next question is how do I go about obtaining a copy of the book for us?
Yeah, no, great. The publisher, Juta, has assured me that the book is available through bookshops. So I think, if you can go, in store, visit your store, ask for the book. And I've also been told that if the book is not readily available on the shelves, you can ask for the bookshop to order it. But certainly I think the easiest way perhaps for most people would be simply to order it online. And the easiest way to do that would be to go to Juta's site, or just simply Google the legal profession in South Africa, and that could take you to the website where you can make a online order. And I think also we will put and distribute, with the video, perhaps we could just also add later a link to that page to make it easier for people who are interested in. But yeah, the Juta has assured me that the book is there, it's available, and I should encourage people to go out and get the copy.
Right, and I think a link is a good idea.
Yeah.
But like you say, I think it's relatively easy to obtain a copy of the book. Look, we've reached the conclusion of our discussion, our very interesting discussion, and I'm sure the audience will agree. But do you have any final comments that you would like to make in relation to the publication specifically?
Yeah. Well, first of all, thank you very much for, again, taking time from your schedule and making yourself available. I appreciate that a lot. And then, yeah, it's been a very interesting discussion. I hope I've covered all those issues. But yeah, for a final point of view, I'd just like to make a couple of acknowledgements, thanking, first of all, family and friends for the support during the writing of this book. And in particular, my wife, Katrina, who's supported me throughout. You know, you've authored a book or two in your time, so it's a time intensive project, and so a lot of sacrifices were made by her and by family and friends, and I appreciate that. And then I guess secondly, also to my employer, Stellenbosch University, who allocated research leave in 2019, which made it possible for me also to complete this book. So that's with regards to the acknowledgements, and perhaps also just finally also to Juta, yeah, for the assistance that they gave Stephen Alcock in particular, but the editorial team, they were really great. So a lot of thanks to them. And then, yeah, I think as a final thought, I would just say that, you know, ultimately the status or the position and the condition of our constitutional democracy depends to a large degree on the quality of our judges, our courts, but also of our legal practitioners. And we need people who are technically proficient, know the rules, great at practical problem solving. That is fantastic. But we also need people who understand and promote you know, values that are then captured in the Act, and particularly the Code of Conduct, furthering social justice, promoting access to justice, and also contributing to the development of the law. And I hope that this book plays some part also in that. But thank you.